Hello.
Hi,
Am I,
Professor. No, no, no.
you good? Yeah?
Yeah.
Thank you. Looking forward.
Good afternoon, distinguished guests, ladies and gentlemen, and colleagues. Welcome back to the Johannesburg Arbitration Week. My name is Sinako Lindazwe, member of Advocates for Transformation and the Johannesburg Bar. This session is brought to you by Advocates for Transformation and the Johannesburg Bar. Before we start, I'd like to apologize for the delay. We have two distinguished speakers that were part of this panel and would have loved to be here today, but unfortunately could not join us this afternoon. We apologize for that. Africa's energy and infrastructure sectors are undergoing structural transformation, and the commercial landscape is being shaped in real time. Our session today, titled Energy, Infrastructure and Transition Risk, Arbitration at the Center of Africa's Commercial Transformation, could not be more timely. This conversation positions Johannesburg not merely as an observer of continental change, but as a forum capable of hosting and adjudicating disputes that inevitably accompany it. So thank you for joining us and contributing to this important discussion. We are privileged to be guided this afternoon by our moderator, Advocate Kerusha Pillay, a seasoned legal professional with 15 years of experience as an advocate, alongside a distinguished panel comprising of Advocate Dintle Duke, who is an esteemed Lesotho-based lawyer, serving as president of the Law Society of Lesotho. He practices in insurance law, employment law, and risk management at Duke and Scholz Inc. in Maseru. Our second speaker is Mr. Peter Chisebe. Mr. Peter Chisebe, an experienced commercial law attorney and former commercial law lecturer, previously practiced at Worksmans and ENS prior to co-founding TGR Attorneys with other two partners. We also have part of our panel, Mr. Miselo Freedom Kumba, who is a South African attorney and legal academic, currently lecturing in the Department of Mercantile Law at the University of Pretoria. He specializes in banking law, international trade, and investment law with over 14 publications in national and international journals, and is currently pursuing his LLD. As part of our panel, we also had Advocate Pule Sileka, who also has 25 years experience practicing as an advocate and is a senior counsel for 10 years. He is also the chairperson of the Legal Practice Council. And we also have Mr. Clive Hendricks, who's a prominent lawyer at Marais Hala Hendricks Attorney. He has extensive experience in various areas of law, including dispute resolution, litigation, administrative law, and corporate and commercial law. Ladies and gentlemen, please help me welcome our distinguished moderator and speakers to the stage.
Good afternoon, everyone. Welcome to our session this afternoon, I beg your pardon. Thank you for joining us. We do hope that you enjoy this discussion. As you've heard, we have a very esteemed panel of speakers that are going to share their insights and very practical advice. So Linhle, can you share with us some insights on your work in developing the arbitration infrastructure frameworks in Lesotho and the SADCE in the context of the resolution of energy infrastructure disputes?
Thank you, Madam Moderator. That's a fully packed question, if I have to admit. But my work in developing arbitration frameworks in Lesotho and also in the SADC region can be described as three-pronged. Firstly, it involves institutional development. This simply means the creation of credible and trusted arbitration centers more on the administered arbitration side, not too much on the ad hoc. So in that regard, we have already partnered with AFSA to sort of create AFSA Lesotho. This is because I learned building on the Malawian journey that it can take forever to set up an arbitration center and then make business, to trust it, have confidence in it, as opposed to actually bringing an already existing and working, tested and tried an arbitral center. So we'll have AFSA Lesotho based in Maseru. We are also going to be very vocal about positioning it as a seat of arbitration, the preferred one, no longer Sandton or Cape Town. But that should not be understood to imply competition. We are in a synergistic marriage towards achieving certain goals that we mutually share. The second one obviously involves professional development, because we need lawyers who are proficient and qualified in arbitrations and commercial mediations, because then it goes back to that confidence I talked about. So training alongside AFSA and other credible arbitration institutions in the SADC region. And then finally, it goes back to regional integration, because no African economy should be siloed or independent from others. We are interdependent to a very large extent. And as can be seen, our panel is about energy and the infrastructural development, and then the mix of arbitration in there. Most of these projects, you would agree with me that they touch on different jurisdictions. The contractors will be coming from a certain jurisdiction, the contract concluded elsewhere, implemented elsewhere, financiers or the money coming also from elsewhere. And then when there is a dispute, it will impact everyone who's involved. That's an opportunity for us now to integrate, because I do not propose that we create one global legal system. That may not be possible, but it presents an opportunity to run away from fragmentation and introduce arbitration not as an alternative dispute resolution in the commercial sense, but as the preferred one, not alternative. So that's basically my insights into that. I believe if we can achieve that, then infrastructure and these energy projects become bankable. Thank you.
Okay, thank you for that very insightful response. I would like to move on to Peter. Peter, can I ask, can you advise us on the importance of understanding the regulatory landscape at the inception of an energy transaction, for instance, in the case of a 100 megawatt IPP project?
Firstly, thank you very much for inviting me to be one of your panelists to discuss this important matter. It's very, very important to understand the regulatory regime, in relation to projects of this nature, because there are a number of laws that apply relating to projects. For example, you need to understand the law dealing with the water rights issues, because water is quite key. The other element of understanding regulatory is also to understand the environment in terms of NEMA. So you need to be able to navigate, the environmental issues. I'm sure some of you might have read that in the Eastern Cape, those towers that were actually killing some birds, and it became a major issue. So one needs to conduct and understand those issues. And as in the context of South Africa, we still have land that falls under the traditional leadership. So if you are building, your power line or power station in those areas, you need to understand the property rights issues and how to deal or make decisions from the traditional, authorities' point of view. Whether you are dealing with the communal property association or you're dealing with the traditional leadership. So those are some of the key points that needs to be understood in the context of the regulatory. You also need to understand, how NERSA regulates this, because you require licensing and the regulatory regime is quite stringent. So especially for foreign partners who inject money, it's important to really have some understanding of the laws that applies in relation to that. And all those things can trip you if you proceed to implement a project without having considered them. Thanks.
Thank you for that. Peter, can I ask you a second question? Can you advise us on the importance of structuring a transaction to mitigate the legal risks, once again from the beginning, as opposed to dealing with it when there's a dispute?
It's a very interesting question, and I would like to answer it this way, especially in the context of South Africa. And many people don't understand the issue of the equality of bargaining power in negotiations. And why this is relevant is if you look at the source of contract law, it emanated in England among ship merchants who felt the need to regulate their business affairs. And that has since transformed into something that every day to day contracting is a daily thing. For example, you hire an employee, it's not a matter of saying you've hired, you have a contract. So in that context, it's important to understand, the contractual parties and the rights that the parties have. And it's not a matter of really having a good contract. It's a matter of actually understanding the risk associated with that contract and making sure that those risk mitigating factors are dealt with within the contract. For example, it's important that when you embark on a project of this nature, particularly project finance, you have people who are able to first conduct a due diligence, environmental studies, those kind of issues. I'm sure, as much as not a related issue, some of you might have heard about a development in Cape Town, which was stopped because a very unique lizard was discovered, which was last seen in the 1800s. And suddenly someone said, no, this is a sensitive area. We found this lizard, and if we tamper with this, that is territory. So we need to, it became an issue. So you need to conduct a due diligence using experts in the particular area who are able to guide you in terms of what you need to put in there. And the other important things is undertakings in a project of this nature. There are delays. I mean, for example, we are facing some very weird weather in South Africa this year. The Kruger Park is flooding as of yesterday. So if you are involved in a project of that nature, this weather issues becomes relevant because you've got a timetable in terms of which you need to deliver and you've committed to other people. So those kind of things need to be built into the thinking in terms of how you want to structure your project, and you need to mitigate risk. But more importantly, in most of these projects, the person who pays the purse is the one who controls what's in there. So your role is to ensure that you really don't come second best completely. You need to try and balance the scales of negotiations, the bargaining power, which is not that equal. And especially the skills that are required for contracts of this nature are mainly based in foreign jurisdictions. And that is why, like the APC contractors, and you need to really have some clauses that protect you in the event that things are not delivered on time. And you may even insist on the indemnities and warranties so that the people you're dealing with need to warrant that they will be able to deliver and they have the skill to deliver. Thanks.
Thank you very much. Misello, can we now move on to you? Thank you. Can I ask you, in your opinion, are the existing contracts and investment protections becoming a source of conflict?
The area in which I specialize in is on transnational business law. So this touches on foreign direct investment and the relationship between foreign direct investment and the state's regulatory powers. So what states should do. So this is the discussion that took place in the morning. Part of the discussion took place in the morning. So what we have, that I can identify the two regulatory instruments that regulate this relationship. One is what we called the old generation bilateral investment treaties, which a short name for it is BITS. The other instrument is investor state contracts. That is as the word suggests, is the contract concluded between a state and an investor. So in those instruments, there are certain provisions contained in it that provides for most of the time for the protection of investors when they come and invest in a particular country. So that so the idea is that you must have a predictable legal system in a country in order to indicate that in that particular country we are an investor-friendly destination. So usually these agreements have now, or these instruments have become problematic in a sort of a way because of the clauses that are contained in it. These clauses are pro-investor, they are unilateral in nature, they provide protection only to the foreign investors and not to the state parties under those agreements. So the result of that is we have, the result of the breach of those standards is the international arbitration mostly. And that's because countries, they consent in advance to conclude these agreements and say, once we bind ourselves to these agreements, any violation of this agreement will take it to international arbitration somewhere in the World Bank or in Paris on ad hoc dispute resolution mechanism. The entire system has become problematic, but African countries are still bound by those type of agreements. The reason they are bound is because on the one hand, we have a need to attract foreign direct investment in African countries. So we have a need to, first of all, to foreign investors to establish energy sources, to have those projects that are still fossil fuel as opposed to renewable energy. So a lot of population within the African continent still lack access to electricity, for example. And so the need is there's a dire need for attracting foreign direct investment. But at the same time, the problem is that these instruments they bind states to commitment that they usually later regret on. So the usual provision in an investor-state contract, for example, will be a provision called stabilization clause. So the stabilization clause will say that the legal framework in your jurisdiction must be stable for the duration of this project. So these projects are about 30 years or 25 years. So the legal framework should be stable and provide protection to foreign investors for as long as this project exists. If you change the regulatory framework, you are then going to be taken to international arbitration and being sued a large sum of money, which eventually threatens the GDP of these small and developing countries. The result of that is that we have, on the one hand, the issue of those stabilization clauses on investor-state contracts. On the other hand, we have the bilateral investment treaties, which are public international law instruments and a mixture of international commercial law instruments. Under those treaties, we have expropriation provisions, but the expropriation is not a direct expropriation, which is usually what happened in Zimbabwe or countries where there's direct expropriation, you forcefully take people's property. There is something called indirect expropriation under those bilateral investment treaties. And indirect expropriation is where your country, under its sovereign power, passes legislation in order to advance its social welfare programs. But from an investor's perspective, the problem with that is that you can, by passing that regulation, diminishes the value of the investor's property. So if you are diminishing, you are committing an indirect expropriation. So this is what happened in cases like Forestry in South Africa, where we dealt with the issues of Black economic empowerment, where the previously disadvantaged people were to have access to mining, all of the requirements that were required under the Mineral Legislation Act in the country. The result of that is that South Africa was sued for breach of those particular provisions, the indirect expropriation, because from an outside investor views those policies by their very nature as, first of all, discriminatory, they advantage a particular group, and then secondly, that they are indirect expropriation because they diminish the value of their investment. Another provision there is a provision dealing with something called fair and equitable treatment. There is expansive interpretation in terms of the arbitral tribunals. They have interpreted that in a wide way to include legitimate expectations of investors. So when the investors say they have a legitimate expectation, what they mean is they are expecting to make profit out of your country, and they're expecting that your laws will be stable for as long as they are there. And your ability to pass the law, then what it does is it changes the stability that they expected. And as a result is they take you to international arbitration for violating those treaty standards. So that's the problematic nature of the investment law regime with these two regulatory instruments, and the move towards the from fossil fuel to renewable energies would require some government interventions. So those interventions, what they'll do is they'll pass a law that says, for example, that talks to local content requirement, or that all of the resource nationalism issues. All of that would intervene or would actually conflict with the existing agreements where the investors were guaranteed that they will be protected for as long as their project exists in your country. For a period of 30 years, you should not violate those provisions. On the other hand, the measures that the state can take in advancing this renewable energy project can constitute an indirect expropriation. So the result of that is those are two conflicting problems that can arise out of the laws that are being made in the African states. There are just a lot to talk about on that issue, but I'll leave it there. I'll address some with the next question.
Very well. Thank you for that very comprehensive response. I'm sure when we get to the opportunity for the audience to ask questions, that you are going to be getting a lot of questions.
Okay.
Linhle, can we come back to you? In respect of the lack of coherence among legal systems in Africa, do you think that there would be any benefit if, as you mentioned, we can't create one uniform legal system, but creating a little bit more coherence in the legal systems across Africa?
Thank you very much. Once again, I want to agree with you. We don't need to create one legal order, but in the midst of our distinct legal orders, we should strive for capability for them to work together. It's because I've seen that projects in the energy sector either thrive or die at the altar of uncertainty. Not because the sun decided suddenly to stop shining or the wind decided to stop blowing. That's never the collapse of energy projects. It's mainly uncertainty. So if we can have certainty in the harmonized system, access to land, which is certain, the approvals, tariffs, all of these things, but more importantly, the certainty that when a dispute arises, and it inherently will arise, we need to have the certainty that the dispute resolution mechanisms would actually work. If we are that certain, then this would translate into increased investor confidence. So I wouldn't want to stretch it beyond that. I'll come back.
Sure, thank you. Peter, can I come back to you, please? You've spoken about the regulatory landscape, and you've also spoken about structuring the transaction properly from the beginning. Can you give us a very short overview, or comprehensive if you would like, of the importance of ensuring that your transaction has the correct commercial arrangement from a corporate governance perspective at the beginning? Thank you.
On an energy project, it's important to understand the need to have people with the appropriate skills to manage and direct the affairs of that company. You know, there's something very interesting about, our company law, in that, unlike some of us who are sitting here, who have gone to law schools and other places to study to become law, being a director of a company doesn't come with you having undertaken any training of any sort. If you were to join a Pick n Pay as a cashier, before they allow you to operate a till, they train you, but directors are not. But the importance of what I'm trying to say here is, if you put a board of social workers with respect to be your board members on an energy project, you're going to run into serious trouble. So the Companies Act doesn't govern how you appoint, but it's up to you, because Section 66 gives the power, of the board to manage the affairs of the company. And Section 76 actually sets out some stringent rules in relation to fiduciary duties. So the important part in setting up the governance model on a project of this nature is to ensure that you've got the correct mix of skills. Let me give you an example of how challenging this thing could be. A few years back, I was a chairman of an SOE which was responsible for building roads. And because of malfeasance in that business, we could not trust most of the things that the executives were telling us. And I recall when they came and said, there is a bridge which they think is going to collapse in the next rain, if there's next heavy rain. And because we were suspicious of what they were saying, and I'm a lawyer, I don't know anything about engineering, we said, no, we don't think that we can prioritize that, let's put other projects. Then we were told that it looks like the situation is worsening. We decided to go on a trip to go and see this bridge. I had my spectacles on and I looked. When the engineer said, you see, that thing is under stress there. That pillar is under stress. And I said, what stress is this? I just couldn't see. And lo and behold, when it rained, that bridge collapsed. So the essence of what I'm saying is, when you put together a board of directors of a company, particularly in energy, you need people with the skills. You cannot supervise something you don't understand. Otherwise, people will come and tell you things that you don't know. That's one. Two, the important document that you need to consider to avoid this kind of issues is what you put in the MOI and the shareholders agreement. You need to be able to understand what provisions you need to include. And if you have a minority shareholding in the company, you may want minority protections. If you are the majority, you need to resist, and limit them to those that are required in terms of the Companies Act, where maybe a 75 threshold is required. So it's important to understand that. And there is something very interesting in the context of project finance, which I have a serious issue, is what they call the observer status. So if you look at Section 26 of the Companies Act, it sets out the information that outsiders of a company can get. But having an observer in the board, which you can actually contract in an MOI, to me is quite problematic because that person doesn't account to anyone but to the shareholder. And if he or she has signed a confidentiality agreement, the question becomes, why then have that person? What does he say to the shareholder when they meet? Because remember, the limitation of information that the people can have regarding the company is there. So here you are in a project finance, you have a shareholder who doesn't have the right to appoint a director, but wants to insist on an observer. And I'm seeing that often, and I'm asking myself, what is this? How do you deal with it from a company? He doesn't owe any fiduciary duty to the company. And remember, the things that get discussed within the board are quite confidential, but he has access to them. So is he there to scare you like an elephant or a lion that you can see with its posture? If you're African, this thing will injure you. Or is he there to play the role of a spy? So those are some of the things that you need to put in place. And what I'm finding to be a problem also in the governance is making the participants understand their rights, in particular communities. Because these kind of projects, if you know about them, you will understand that there will be a project company, there will be a technical company, there will be this, there will be this. All those things that are happening, including the marketing and the technical services, are expenses that must be paid for before a dividend gets paid. So one of the key issues that you need to look into when, thinking about a project of this nature is what I call stakeholder management. Because someone will say, we are a 10% shareholder of a 10 billion rand company, so it means our value is X. But that's not what the dividend is going to be, and that's not what the value is. There are other things that need to be considered. So from a governance point of view, understanding those issues and ensuring that the people that are participating in the project understand that is quite important. I hope I've answered you adequately.
Absolutely, sir. Thank you. Ms. Sello, my next question is for you. Thank you. How, in your opinion, is Africa balancing the need for foreign investment in energy and with the protection of national sovereignty and the interests of the public, which is something which you touched on very little bit earlier?
Yes. So like I said, the need for foreign investment is glaring in the African continent. So we need to create regulatory space for them, for the investors to come and invest in the African continent. But when we do that under these agreements that I was talking about, under the treaties, so the problem that we now have is that the entire regime of investment law is in crisis. So there's a legitimacy crisis of it because of the unilateral nature of the protection that is granted to one party to the agreement, to the foreign investors, the multinational corporations. And states only have very few ways to maneuver under these agreements. So then the problem is then in Africa, the African continent, after having been under this abusive relationship, they have been called to account in the international arbitration and to pay large sum of money. And the cost of these arbitrations are a lot to transport lawyers or just people from the attorney generals of these African countries to go to the World Bank exit place to make the arbitration. Also, there's just a problem with the arbitrators themselves. So the entire regime then is problematic. So the problem arises from the substantive obligations that are found on the treaties and also on the investor-state contracts, which are unilateral protection, they preclude the countries from passing laws the way they want to pass them. So this is a concept called regulatory chill. So because a country is sovereign, it cannot be dictated by outsiders on what law it should pass. Because of sovereignty means that the law that the country deems fit, it must be able to pass the law without being concerned with the outside parties. So that's the sovereign state, by definition, what makes up the sovereign state, that it passes its law the way it deems fit. So then the problem with that is under those treaties that the passing of these laws was problematic in the sense of frustrating the expectations of investors, in the sense of the measures being regarded as expropriation, or the measures regarded as themselves as discriminating foreign investors and domestic investors. So if you have a domestic investor, a South African investor who's investing in your country, you want to empower those, or you want to have local industries that you give some support. The international investment law demands the same support to the foreign investors. If you don't, you are in breach of the provisions of the treaty. So the result of that is that there's contestation in the area between the protection of investors and the right to regulate, which is something that talks about the country's ability to pass the law the way it wants to do. So what the African countries then have done, they have responded to this legitimacy crisis of the law by, at the African Union level, by passing what is called the Protocol on Investment. And at the regional economic level, a lot of our major regional economic communities have passed laws that try to balance the system. So the way they have balanced the system is to, first of all, talk about the right to regulate and expand what should be contained under the right to regulate. And they have also tried to talk about carve-outs, issues that cannot be regarded as discrimination. For example, if there's a public procurement, issue and a local is preferred, so you put that on the treaty. On your drafting, you write that explicitly so that any support that you've granted to the local industry is not regarded as discrimination or yes. So the other thing that they do is they define what is fair and equitable standard to try to explain that investors should not expect any regulatory measure that would be passed by the country in areas such as regulating environment. For example, if a foreign investor comes in a particular country, the investor must comply with environmental impact assessment. So you include those provisions under the treaty drafting. So this is what Africans have done to try and balance the scale from the old generation beats to what is now called new modern investment framework. So they've done that at an African level, at the African Union level, regional level, and South Africa has passed its own legislation and terminated investment treaties with European countries only, left the investment treaty with some African countries, which tells you that South Africa is also concerned with investors that goes to Africa. So they want still to gain protection, so selection there of where you should pick and choose. So that's the situation now we now have. But the problem with this whole framework is that it started around the year 2012 up to 2023 when the Pan-African Investment Code was passed. The problem with that framework is that some of these agreements are models agreements. So what it means that African countries can actually model their own drafting of the treaties in the future from these agreements, but they're not bound by them because it's a model, it's not a binding treaty. The other problem is that the framework that exists within the African continent it's a progressive framework, but at the same time, there are still existing bilateral investment treaties that are binding to African countries, and that is with outside countries. So what that means is this: that if you conclude a bilateral investment treaty with China or with the European countries as an individual country, you can do that without being questioned. The other problem is that they still exist, despite the criticism that we have labeled them, they still exist with the framework, the African framework that on the other side is progressive. So what this means is that all the investment agreements at an African level it places obligations. There is even a clause that talks about investor obligations. It places obligations on intra-African investors. So what this means is that we have investors from the African continent who should assume obligations that Western investors do not have. By nature, these agreements, the African legal framework, as a response to the legitimacy crisis, these agreements are supposed to be binding only to the African continent because the treaty is binding only to the parties to it, not to the external parties. The result of that, there's a lot of work that is not done within the African continent. And again, there's a risk of arbitration within the African continent that's still out there because of the existing agreements. African countries are exposed and they are not doing anything about these bilateral investment treaties. In other words, they are not aligning the investment agreements with the policy framework from the African Union. The policy framework from the African Union, the Protocol on Investment, has provisions about investor obligations for climate change, for example, something that we did not think in the past 10 years that it would have those provisions. So it's permeated by sustainable development clauses. It has obligations for investors for corporate social responsibility, obligations for local communities and indigenous people. All of those are new provisions, are recommended provisions. The African investment law framework then is seen as progressive. But at the individual country level, we have beats that are still pro-investors, protecting investors, and the result of that is that even as we speak, African countries still continue to sign new investment agreements which are pro-investor, despite the existence of the already commendable framework from the African Union. So that conflict and the coexistence of these two principles. And the other thing is the African countries are not terminating the bilateral investment treaties. Only South Africa did. They are not terminating because they don't want to be seen as an investor-unfriendly destination. So instead, Zimbabwe just continued to sign the ZEDA Act, which has similar provisions with the pro-investor. The entire problematic regime is there. The idea, again, is to provide protection for investors, but there's more onerous obligations within the African continent in their relations with each other. And yes, so that's the balance that African countries are trying to achieve to protect their regulatory space, but also to have much more obligations. All we have is just lessons on how African countries can do in the future when negotiating agreements. But again, I don't see African countries doing that, and that's the problem that we currently have.
Thank you for that. It's actually very interesting because I'm an independent power producer, and I think in 2 weeks' time I'm going to meet with ZEDA to look at the investment-ready projects.
Yeah.
So it actually, I agree with what you were saying, because looking at it from a different perspective, and from our investor perspective of the team that we are working with, those very concerns are the concerns that we do have.
Yeah.
But Zimbabwe, for example, is a country which is very investor-friendly.
Yeah.
Yeah. And I think it's quite an important aspect you've raised. Linchle, can I ask, you mentioned earlier, and we've agreed that we cannot have one uniform legal system across the African continent. But the preference would be to increase the coherence in the legal systems. And so would you say there are any benefits in increasing that coherence to facilitate and increase the development of renewable energy projects in South Africa and the African continent generally?
Okay, so I would want to go back to my earlier position that coherence should never be understood to mean sameness in the legal dispensations. What is happening now at the SADC level? We have signed a charter here at the 2024 edition of the JAW, and SADC countries are being represented by their respective bars and law societies. They would obviously be coming from different jurisdictions, whether it's a civil law one or common law one. So in spite of those details or differences, there's an opportunity to be coherent. And I believe that if we were to achieve that coherence, certain benefits would immediately emerge. For instance, if we increase investor confidence by so doing, the flow of FDI will be facilitated. His concern would obviously be at what cost. That's where he would come in at the negotiation side of things. but that FDI is not coming, will not even be an issue. It will also reduce transactional costs because these transactions in the renewable energy sector can be quite exorbitant because we are trying to manage lots and lots of risks. You can imagine for us, we are on our third dam now in Lesotho, which will still benefit, or for the benefit of South Africa. There are negotiations of that treaty where Lesotho is being painted as probably ungrateful because it is being presented as if it wants more out of that treaty all of a Sunday. I wonder if we are going to have similar problems with Botswana because we have already agreed that we are going to have a fourth dam specifically for them. We'll see how the negotiations go. I'll follow them and I'll let you know, my brother. But the reduction in this dispute resolution risk would obviously factor in to impact the transactional costs in a way that reduces them. So the benefits are there. We cannot debate about them. We just need the willingness to stop theorizing and strategizing and actually do the thing. That's why I'm so comfortable that, and in fact, my hopes are very high that with the charter under the SADC law societies and the bars, even with our distinct and different legal systems, we can make our arbitration, at least our arbitration frameworks, be more coherent. And when we set up our arbitration centers, they will have that coherence. And I've already said, not at an alternative dispute resolution perception or perspective, but as the preferred mode of dispute resolution. Thank you.
Thank you, Linhle. Peter, can I move on to you, please? I think a very important topic is the issue of project finance and the project finance transaction specifically, because without that, no projects can move forward. So can you briefly identify some of the challenges that one regularly encounters in those transactions, and then any risk mitigation measures that you are able to propose? Thank you.
I think there are a number of issues that need to be understood. I'm not sure.
Yeah, I think it's off.
Is it off? So I was saying, I think there are a number of issues and a risk associated with project finance that must be understood by investors. Firstly, a project finance is very much non-recourse based. And what does that mean? It means that whatever recourse is available is based on the project on its own. So that in itself requires some understanding as to how we're going to share the pie and sharing the security package. For example, you will have, the senior loan, you'll have the, mezzanine and equity and things like that. So when you are a participant, it's important that you understand how those security package will be dealt with in the agreements, and you must actually make sure they are dealt with properly. That's one. The other challenge that I've seen in project finance is that there are international funders who are involved, who are governed by, among others, the anti-corruption laws, stringent anti-corruption laws. And we worked on a project in one of the countries where some politicians, what we call political exposed people, were involved. And the project had to be stopped because the partner, they happened to have some American subsidiary, which follows very stringent laws on corruption and those kind of issues. So you need to be mindful of that. So the way to go about it is in selecting your partners, you need to understand, one, what are the corruption laws that apply? And two, how do you navigate around that? And I'm not in any way promoting corruption, but to ensure that you don't caught up in a situation where you'll have to be asked to remove a partner who may be critical. The other issue that I've seen is that people don't understand that having a license alone is not, it's a first step, but without any connection to the grid, and you get the budget code from the National Transmission Company, you have a challenge. So it's like me coming from Chakuma and buying a Ferrari. There are no roads for Ferraris there. And by the way, in my village, a Ferrari looks like an ugly thing because that's what they think it is. What is handy there, it's a bucket that can carry firewood and water. With that thing, which sits two people, it's just meaningless. So it's the same thing when you look at projects of this nature. You need to understand the regulatory regime, the connection to the grid and all that, and actually plan around it. And the other issue that I've seen projects of this nature being tripped is the issue of the currency fluctuation. Because in most instances, these projects are based on the dollar. And the rand, as you know, has issues. So when there's something like that, it's important that you factor in that in your thinking such that you don't have the surprises. And if there are surprises, you've got a war chest to deal with it. And the other problem that I've seen in projects of this nature, which needs some careful thought, is understanding that laws are territorial. What does that mean? If you are running a cross-border project into Mozambique or Lesotho, not only are you required to understand the laws of South Africa, but need to understand the laws of that country. And that is why working with lawyers and advisors in that jurisdiction to analyze exactly what laws apply to you and how to navigate through them is important. And lastly, one of the key issues here is the issue of the time frame. You embark on this thing, you're building this project for 5-7 years. You understand that there will be somehow time delay. And it's important that you have penalties to say, if you don't finish this project on time, the penalty is X. And in your negotiation with the likes of the electricity company, the issue of the take or pay is also important. So depending on who you are acting for or who is advising you, it's important that you understand those things, take or pay. And if you don't put those things in, you run a risk of having serious financial challenges with the project.
Thank you for that response. Ms. Sello, my last question is, in your opinion, what lessons would you say Africa has learned from past investor-state disputes and specifically disputes in the energy and infrastructure sector?
The lessons that African countries have had is the extent to which they have been accused of violating investment agreements, and they only have contributed to the jurisprudence of international arbitration as respondents, not as parties who can initiate disputes. So the rules are such that only investors are accorded opportunity to initiate disputes. The investor, the states, though they are party to the agreement, they can only act to defend themselves. So they can have counterclaims in the investment law regime, but they are not. They do not initiate dispute. So that's the problematic nature of the entire investor-state dispute settlement mechanism. So the result of that is that African countries, South Africa in particular, has said that these disputes are best placed when they are decided within the local courts. So the idea that the African countries are not suited for deciding international commercial arbitration, we say in South Africa it does not apply because of our developed legal systems. And therefore, we should go to mediation, arbitration, and to our local courts. We have removed the need to go to international arbitration altogether. So the ISDS system, something investor-state dispute settlement, is not part of our legislation in South Africa. Moving forward at the SADC level, South Africa managed to influence the decision there in the negotiations of the agreements at that level to remove this problematic investor-state dispute because of its unilateral protection to investors, not to any other stakeholder. So because, for example, if we talk about the investors, if you invest in the mining sector, you have the investors have a potential of displacing local people out of their area or to leave the areas polluted and with no recovery plans. So the result of that is human rights abuses to the local people. But those local people under the framework have nowhere else to go to resolve their disputes, and that's the problematic nature of the international arbitration regime as a whole. So African countries then are trying to reverse that legitimacy crisis of international investment arbitration by introducing measures such as talking about what is called diplomatic protection. That's like a political engagement at political level, and then the mediation level, that we should resolve our dispute at the mediation level. And then a lot of these agreements, they talk about the arbitration centers that should be established in African continent. So you will have a protocol in investment that says nothing about international investment agreement, investment arbitration, but it says that dispute arising out of this agreement should be resolved by an African arbitration center. So the question then over time has always been, why should we prefer international arbitration when AFSA can resolve this dispute? What stops arbitrations within the African continent, arbitration centers in AFSA to resolve the dispute, or Kigali International Arbitration Center, or Cairo Regional Center, or in the case of COMESA Investment Court? What is the purpose of having those centers in these agreements if they are not going to be used? The problem with that is African countries, again, the same argument. They are still bound by investor-state contracts, investment agreements that says investors, when they have a problem with these agreements, they are going to take African country, any country, to international arbitration. And when they do that, they don't have to exhaust local remedies. They don't have to go to the Constitutional Court in South Africa. They bypass all our local court systems, directly go to international arbitration, which has a lot of problems on its own. The structure of it, the unilateral nature, the idea that only investors can initiate dispute. The arbitrators themselves, the cycle of arbitrators will sometimes act as counsel for these multinational companies. The lack of diversity within those arbitrators, the party appointed arbitrator that we trust with this type of work instead of locally trained judges who will understand local issues. So African countries are trying to reverse that by introducing mediation. Again, there is no experience yet about what is the role of these African arbitration centers. There's no gained experience yet in terms of what they can potentially do in the future. So that's exactly where we are.
Thank you for that. We've come to the end of the panel discussion. We have exactly 4 minutes and 45 seconds for questions. So can I invite some questions for our panel members? Thank you. I see we have 2 hands up. Do we need a mic?
Oh. Good afternoon, I'm Sean Gibbs from Hanscom. I was involved in the Eskom power projects at Medupi and Kisili, and at the time Rob Mawson helped Eskom draft FIDIC Yellow Book and Red Books, and he was very cautious about over-amending them. But 2 particular amendments that he did involve dispute resolution. Is firstly that they had the Association of Arbitrators of South Africa as the default nominating body for the dispute boards if there wasn't a consensus. And then similarly with the arbitration process, the ICC was crossed out and it was the Association of Arbitrators. Are you seeing people moving towards AFSA when they're amending the FIDIC contracts now used in South Africa as this default nominating body?
Can I perhaps ask which of the panelists that question is directed at?
Any of them, I'm not sure who's got the most experience with power and energy.
Okay, thank you for that. About some. Sorry, can I ask for a very, thank you for the background, but can I ask for a very concise question so Peter can answer? Thank you.
In terms of the FIDIC contract, the default process for dispute boards or arbitration is that the ICC will step in if there isn't consensus or agreement. He's asking what you're seeing in South Africa at the moment. Is the ICC being crossed out and a local institute being used? So the example I gave was the Association of Arbitrators. I understand now that most people use AFSA instead of them. So it's really who are you seeing replacing the ICC in the FIDIC contracts?
I think the question is who do we see replacing the ICC in the FIDIC contracts?
I can attempt to answer the question. The International Commercial Arbitration, they're governed by party autonomy, the principle of party autonomy. And this is a well-recognized international commercial principle. It's well-recognized, well-known. So parties to any international agreement, they are free to choose whatever center they want to choose. It's not a matter of replacing one center over the other. It's a matter of the parties' choices to that particular agreement. I think I'm trying to answer your question.
No, that's fine. So typically with the FIDIC tendering process used on the Multilateral Development Bank or World Bank, the employer tends to be in the driving seat in terms of making the amendment to the particular conditions. I was just really trying to find out what's happening at the moment on the ground in South Africa.
Then I can pass that question on.
I'm battling to hear him because of pronunciation, but I'll try to answer based on what I'm understanding him to be saying. If I heard you correctly, you are actually talking about the choice of, the arbitration fora. In other words, between the FIDIC regulated arbitration and any other arbitration. Am I correct?
Yeah, so the
Yes.
FIDIC, default process FIDIC is it's ICC. Yeah.
To me, that issue goes back to the issue of the governing, the equality of bargaining power. Because whoever is injecting a lot of money or skills into the project will be the one who will push for which jurisdiction it's going to be. Let me give you an example. I've been a commercial attorney since 1998. I may look young, but I'm very old. And during this 27 years of practicing law at the highest level, I still have to draft a single agreement that is subject to court to deal with disputes. Arbitration is a deal breaker. So, meaning that even in that context, whoever is controlling the project will decide where the arbitration should be. Thanks. I hope I answered you correctly.
Thank you. Thank you, Peter. There's one more question from the gentleman behind. Thank you.
I'm actually from Lesotho Highlands Development Authority. So I am on Podiadi Dam. We're using FIDIC, and generally the arbitration center that we identify is Mauritius with a seat in Botswana, just for the interest. But my question was, what I wanted to ask is, at this stage, Lesotho only has got a national arbitration law. Are there any movements to have that changed to or added on to have an international arbitration law, and how will that influence the lack of an international arbitration law having a seat in Lesotho?
Can I, just for clarity purposes, ask who the question is directed at?
Our friend from Lesotho.
Thank you. I thought so.
Okay. I'm on the spot, so I'll attempt your question. Our Arbitration Act, as far as domestic arbitrations would be concerned, is a very old piece of legislation, a 1980 Arbitration Act. Still uses terms like umpire, like who still uses those terms now? It's 45 or 46 years old. So there's a great need for not only amending that law, but for doing away with it and coming up with a new legislative enactment which is more aligned to the times. It was modeled alongside the old South African Act, I think the 1960s, 65 years. It's a carbon copy of that. But South Africa still has it, so they are more archaic than us. But, but unfortunately, but fortunately for them, they have the 2017 International Arbitration Act. We have had some lessons and a bit of copying and pasting to take from that 2017 Act. I know Advocate Hank Lowe is here somewhere. Yes, Hank has a proposed bill for the International Arbitration Act of Lesotho, which is yet, it is yet to be presented before the powers that be workshopped, and then ultimately presented before the legislature for enactment. And I've gone through the act or the proposed bill. It's a good one. So I think if we have you as the Highlands Water Project behind that bill, supporting it, we may get to the finish line sooner than later. But that's basically that. There are moves to modernize, and also cognizant of the fact that there's a need to not only modernize but also to harmonize. So the move is there. We hope to get to the finish line very soon. Thank you.
Thank you very much. Unfortunately, ma'am, we don't have any more time for questions. We've got in front of us, which everybody else can't see, a huge screen with red and white writing that says time's up. Thank you very much to our panelists for sharing your wisdom and insight. It was quite interesting. I think there is another panel, which I have no doubt that you will enjoy very much. Thank you.
video. Yeah, absolutely. I'll just be like that. I'll talk to you.
All right. Are we on? We are. Hello, everyone. Welcome to the final session in this breakaway room before the gala dinner tonight. I'm excited for this conversation. Our final session is titled The Use of AI in Arbitration Proceedings. And today we're going to be exploring how emerging technologies are beginning to shape the arbitration process. Now, as AI tools become more integrated into legal practice, they do raise important questions around efficiency, ethics, and of course, procedural fairness. So to lead this conversation, I would like to invite, well, our panel is already on the stage, but our moderator, Alexandre Wachenheim, who is VP Institutional and Legal Affairs. We also have Sarah McKenzie, Fola Adeleke, as well as Sylvia Papadopoulos. Please give everyone a big round of applause and our moderator.
Is this on? Yes? All right. And I think we can also say thank you to our fabulous host. She has been doing an incredible job throughout each session. So thank you for introducing all the panel. As she mentioned, my name is Alexandre Wachenheim. I'm VP of Institutional and Legal Affairs at Jus Mundi, and it's my honor to host with Jus Mundi this panel on the use of AI in arbitration. I'm going to take 10 minutes to introduce you to what we do at Jus Mundi, to give you some very practical example of how we are shaping AI to be used in arbitration. And the real star of the shows are just here, and they're going to perhaps contradict me, or at least share the experience they have. We have a pretty impressive panel, which I will introduce you in 1 second. That's me. I started as a lawyer. I was an arbitration lawyer for about 10 years, and then I joined the legal tech world. You can also see that from my outfit. Here is all legal and the tech coming all the way down. This is our team in Paris. We are about 100 now, really building the future of AI in international arbitration. So Jus Mundi is what we call in French a société à mission. It's a mission company. So beyond, of course, trying to make money and being a commercial company, trying to build AI in arbitration, we do have a global mission, which is powering global justice. And the way we do that is by democratizing access to legal resources. And the way we do that is through partnerships throughout the world. Today, we have over 100 partnerships with arbitral institutions. We've been accompanying the movement to democratize those legal resources, accompanying the transparency movement since we started 6 years ago. We've been publishing more than 15,000 arbitral awards from around the world in many, many languages. We're very proud that AFSA is one of our African partners. We've been partnering with AFSA for about 2 years now. And we've been publishing and trying to make accessible judgments from around the region. And soon, of course, we will also try to have arbitral awards published. We are a tech company, and so what we're doing is building an ethical AI for arbitration, and I stress on the word ethical. This is going to be part of the conversation we're going to have with our speakers today, and really about the underlying technology. Today we're using mostly agents, and I'll come back to that. Another pillar of our mission is interconnecting legal words. It's really to make sure that we interconnect the entire ecosystem, arbitral institution, lawyers, governance leaders, etc., under one roof. These are all the partnerships I've told you about, more than 100 here in Africa. We have approximately 9 partnerships, again, stressing the importance of our partnership with AFSA today. How are we building an ethical AI at Jus Mundi? So first of all, we have a governance in place, and we have a very strong mission committee who actually oversee and challenge each and every business decision that we make to make sure that they do comply with our global mission of building an ethical AI. You might recognize some people from the continent, Thierry from Rwanda, Emilia Onyema from Nigeria, Professor Abdel Wahab. Those are really strong people. And I can tell you, I'm in charge of that mission committee. They challenge us every day to make sure that whatever we promise in terms of building our AI tools, we do deliver. So today, discussion will be around the use of in arbitration proceedings. So I've mapped out what we believe and what we see at Jusmundi, also from our clients' perspective, where AI is used, and we'll also confirm or infer or contradict those assumptions with our speakers. So the first place where we see AI used in the arbitration life cycle is really in the preparation stage. And so pre-arbitration, how do you identify market opportunities, helping you to draft pitches for your client. Early case assessment is another use cases that we're seeing. How do you evaluate the chances of success? How do you secure various stakeholders? Phase 1, preparation. Phase 2, it's really about case management, and we'll dig into that a little bit more deeper as we move on. Tribunal's constitution, how do you select the right arbitrator? Can you use AI for that? This is actually one of the most critical points that we have to address in terms of ethics today at Jusmundi. I'll show you in a second. We have various databases. One of them is around arbitrators' caseload and experiences and publication. So when you plug an AI tool onto that, you have a myriad of ethical issues coming over. Reputation, harm, et cetera, et cetera. And so that's why we're very careful into how do we address those parts. You can use it in written submission, of course, for the preparation of hearings. You can profile arbitrator. You can find weaknesses in real time for cross-examination. We've heard a lot of our clients using it for that use cases. But it's also mostly increasingly used for tribunals deliberation, awards drafting, etc. And these are more contentious use cases, which we will be discussing. And finally, post-arbitration, we have a myriad of use cases. You can navigate a lot of complex set-asides, enforcement proceeding regime, which you can compare and use an AI tool for that. I wanted to mention, and focus on bias. This was the opening of Paris Arbitration Week. I forgot to mention, I'm on the board and I'm vice president of Paris Arbitration Week. And frankly, I know what it takes to organize an arbitration week, and I really want to congratulate the JAW committee, because the week is really spectacular. We've had a really amazing panel. The venue is great, so really congratulations. And I feel and I know what it takes to be there. So thank you for allowing us to do that. And so bias was the start of the conversation we had at Paris Arbitration Week, and it was really an interesting conversation, which I look forward to dig a little bit more with you. So we had conversation about 2-3 years ago about whether AI will replace lawyer. I think we've passed that conversation, and we're a little bit more advanced into what is going to be the impact into lawyer. And so today, if you look at the press, we see a lot. Well, AI is accused of, and you can see this is a BBC article, AI chatbots could make you more stupid or dumb. Is that really the case? And I look forward to hearing from our panelists again. I think the better news is that it depends. And as a lawyer, we like that answer, it depends. And of course, again, building an ethical AI from our standpoints is also to have those conversations about whether AI is bad or is good or is improving or is deterring to critical thinking. How is artificial intelligence impacting human legal reasoning? Those are questions that we feel we need to address also. The way we see it is more AI as an analytical partner. And the way we build it, and I'll be a bit quick on that because it's a bit techy, but we basically have an agentic layer of AI, which we call UseAI, security bulletproof, of course, which we build on top of our database, which is a database of multilingual, a number of arbitration structured data or private documents from our users. We also build our own models, and this is something very new. And because arbitration demands its own intelligence, we couldn't find out there with the big LLM providers some that really get to the nuances of what arbitration is and would actually have those reasoning. And so we build our own models. There are a few use cases, and I'll before showing you very practically, I'll show you that. We use, and I think the way we can use AI is really as a tool to help you as a rigorous thinker. So for example, and that's an example which we like, the Nemesis prompt. So it's really how do you make, how can you help surface your opposing counsel's strongest argument? Act as if you were my opposing counsel, identify the strongest counter arguments, identify my legal authorities. And those are very sort of unexplored use cases. Very briefly to show you, this is, you don't see, it's okay. There you go. So this is our AI agents, as you can see. You have a little pop-up because we just announced the release of our new agent. So I'm putting, and this is going to be the only example because I really want our speakers to take the stand. I've put a prompt about the AFSA rules just to show you the way the agents proceed. So here we have a very carefully crafted prompts about the AFSA rules and what are the rules governing challenge, replacement of arbitrators, what are the grounds, what are the procedure, what are the timeline for filing, what is the decision-making authority, what are the circumstances triggering the replacement of an arbitrator. So what you see now, and it will take some time, and I have generated that answer, but you basically see all the steps, all the reasoning steps. This is something new that we've added to overcome some transparency issues that we've had in the past, also to allow lawyers to be in a position to understand exactly what is the AI doing. So while it map out, and so here you have, it's already starting, you have a planning agent, a research agent, an execution agent. It's a myriad of different agents that will work together towards trying to make the best answer to this kind of very long and detailed prompt. This is JustConnect, our platform for arbitrators, etc., lawyers, which really allows you to see people's expertise. You also have institution profile, and I wanted to show the AFSA profile here, in which you have all the data that we've collected and that we've contributed, that AFSA has contributed, all the cases from the region. Again, this is why I'm stressing about the data, because these are the foundation of AI. If you have enough data in a sufficiently diverse quantity to train your AI, you have better results, you have less biases, etc. So this is the example I showed you, and this is the reasoning steps. So you can see here, step by step, exactly how the AI models arrived at the definitive answers. At the end, you have all the sources, which allows you to actually go directly to each source and verify the accuracy, etc. And so again, we moved a little bit from the conversation we had a few years ago about hallucination, how do you tackle those, etc., etc. Now, I will stop here and we will start the conversation with our panelists. They've been already introduced, but I will give them a very brief introduction as well. So, on my immediate right, we have Sarah Mackenzie. Sarah is a fantastic partner at Weber Wenzel. She's one of South Africa's leading international arbitration practitioners. She has extensive experience before the ICC, ICSID, and of course, AFSA across energy, mining, construction, finance disputes. She's our arbitration specialist for this panel. We have Professor Fola Adeleke. He's executive director for the Global Center on AI Governance for the University of the Witwatersrand. Was it correct? No, but sorry, Wits. All right. PhD in international investment law and human rights, and directly involved in shaping South Africa's national AI strategy, Nigeria's AI policy. So he's one of Africa's foremost voice on responsible AI governance, and it's truly a pleasure to have you here. And I think we're doing a little rematch here. So for the insider part, Sarah was supervised by Fola, if I understand correctly, and you already had a panel last year, so we're doing a little rematch. And we also have Professor Sylvia Papadopoulos, was that correct? All right, she's associate professor from the Department of Private Law at the University of Pretoria, acting director of IP Law Center. She's a specialist in AI, technology law, and consumer protection. That's not her first participation at JAW. She was there already 2 years ago, if I remember correctly. And she did a little experiment about generating an arbitral award with ChatGPT. And we'll come back to that, to the findings of that experiment. Where are we 2 years after? What's the takeaways and where the governance has shaped? So we have 45 minutes. We're going to do 15 minutes on 3 segments, and we're going to have few time for a question at the end. The first segment of our conversation is really about use cases, adoption. So let me first start with a question to the audience. Who has used AI in an arbitration matter over the last year? By show of hands? Quite a few people. That's very interesting. All right. And so we used to do those kind of show of hands a couple of years ago. Even last year was pretty like half-half. Now I would say more than 80% in this room is using AI. So adoption is quite on the way. And I will start with you, Sarah. How has AI genuinely changed how arbitration are conducted in South Africa, at least in your, of course, in your experience? Yeah, what are the changes that you've seen?
Thanks so much. And just to, I suppose, touch on the progression that you've identified. 2 years ago, Phil and I were speaking about investment law because that was our expertise, and now here we are speaking about AI. So it really is becoming such an incredibly important part of practice, I think. But the truth is, I think that in practice, at least in my experience in South Africa, but across the continent as well, arbitration is changing because of AI, but it's changing quite slowly. I think the conference scene is a little bit ahead of practice. I think that's because practitioners are at very different stages in their use of AI. And obviously we've seen different firms at different levels within different jurisdictions, but of course, different jurisdictions have different adoption rates as well. At Webber Wentzel, we've of course taken quite deliberate steps to be very forward-looking. We actually have our own tech co, and we've been adopting AI really as responsibly as we can from the very beginning. We are seeing evidence of it in a lot of our arbitrations from our opponents. Often in the case of, submissions that have a wildly different kind of tone of voice from what we've seen up till a particular point, and that makes us suspicious. But also, unfortunately, in relation to submissions that just don't hold up to scrutiny when we start kind of testing the cases that have been cited and the like. So we know it is being used widely. It hasn't really changed the basic nature and progression of arbitrations yet. I think it has improved in some cases the timing and efficiency of the steps that we can take in arbitrations. So we're seeing a bit of improvement at the margins for clients. But of course, with that comes increased risk in the process and in the outcome in some senses as well. So I think there's a lot of concern in the industry at the moment about it really needing to be used in a very responsible way, and that's something we're taking very seriously.
Let me just follow up on that, Sarah. And so Webber Wentzel has already adopted, and I know we've discussed that you've already rolled out a more general legal AI, which is Legora, one of the big two. You have Legora, Harvey, and you're having more and more of those legal tech being rolled out in firms and in arbitration practices. What are you seeing? Where are you seeing AI used in your practice? A little bit more concretely, is it research? Is it document review? And where has it added value, really?
Yeah, so mostly I think in relation to kind of document intensive matters, that's what we found our best use case, I think, so far for it. So that's generally our large arbitrations where we're sifting through mountains of paperwork to work out what needs to be disclosed, work out what the other side has disclosed, work out kind of the evidence that the witnesses need to speak to, etc. We are looking at AI-assisted review tools. We're very excited about the developments in relation to research options, particularly across multiple jurisdictions. We think that's going to be incredibly helpful. So we're excited about your partnership of course, coming up, which I'm sure you'll speak to us about. Hearing preparation, we are looking at kind of summaries of witness statements, AI transcriptions, identifying inconsistencies in records and across kind of what witnesses are saying in the record and the like. I think what we're seeing a lot of positives, but what we haven't really seen at all, and this is I will say an enormous relief to me, is the kind of nuanced judgment that we feared might be coming out of AI when we first heard about it. I don't think we're at the point where you can rely on AI to derive a strategy for you. It'll come up with a whole list of options, and you've got to use your judgment to sift through those and work out what you should actually be using. But we are, we're making good progress, and I think it's really exciting.
Sylvia, go ahead. I can see that
Yes,
you.
it links in with what you have just said. So I think that is the positive side of it. But I think it has something which is not really being spoken about. It's not really being recognized at the moment. So it's a deeper structural problem in the profession. So AI is genuinely very powerful. It helps attorneys counsel a lot. It compresses your research time. It surfaces patterns across large structures of data. And for senior practitioners, it already is showing significant improvement in your turnaround time, in your response time to clients, and all of that. But, sorry, legal competence is not just knowledge. It's judgment built through experience. Exposure to failure, reiterations of your arguments, corrections over time, juniors sitting at the table listening to seniors, and learning by doing, first making mistakes, being supervised, being mentored into senior competent counsel. So what we're seeing from our end and from the university perspective definitely is a big gap in how we're going to get graduates to senior competent counsels. If a lot of what they were doing, sifting through boxes and boxes of documents, is now done in 30 minutes by AI. So that is an issue that is definitely on a lot of tables. We're already seeing decreasing numbers of junior candidate attorneys being taken on by firms, definitely. So these are things that your leap from graduate to senior counsel is now being eroded by what AI can do.
Go ahead, sir.
Yeah, I mean, Sylvia, I think that's obviously correct, and it's something that we as a leadership team at Webber Wentzel are really kind of thinking quite hard about. How do you get your juniors who, as you say, were learning through their mistakes, through the hard grind, actually, of that kind of the work that we now don't have to do, to be at the point where they're able to exercise that nuanced judgment that we know that we're going to need to continue to have at the top levels, and we've really looked at kind of the appropriate point at which you roll out AI tools within a firm. Personally, I think it shouldn't be right away. I think it should be something that gets relied on a little bit later, so that in the very formative years of an attorney's career, they're still doing that. But we also know that junior associates are still going to be required to check what the AI output is. And I think that's an incredibly critical component of an ethical use of any AI tool. We need them to be able to do that check sensibly, and in order to do that, they need to know what output should have been produced. So it's I think a really careful balance where you're weighing up cost and efficiency in your client's interest. When you have a tool that enables you to work less costly and more efficiently, I think ethically you're also obliged to do so. But at the same time, finding a way to create the right kind of progression up into leadership places for attorneys and opportunities for training. So it's a nuanced thing I think the whole industry is going to have to grapple with very carefully.
Well, I think you go right into the hard questions, and I mean, we are here for a frank conversation, and to be honest, we spend, and I spend personally a lot of time teaching, training our users, our clients, students. We have classes around the use of AI in arbitration in a lot of university. You have legal tech courses now in university. And it is a real concern, and I do agree with that, but it's also facing also that there is a huge change in the business model of legal services and arbitration, the way you price, the way you will deliver your services. And of course, interestingly, what we're also seeing, a lot of our clients now becomes general counsel, which was interesting. It was always a segment of the market that we struggled quite a lot for Jusmundi adoption, and now with the AI boom, we have a lot of those legal teams across those users who are now using it, and so there is of course a big shift. Maybe I stay with you, Sylvia, with one more question, and I think I'll move a little bit on the governance aspect, as also related to the adoption. What, according to you, determines whether AI tools are adopted responsibly in legal practice? What is the governance concerns that are already happening? We've touched upon already. We heard bias, hallucination, etc. But what is, in your view, today the most concern that we should be mindful and careful of?
Well, I think responsible AI use is very loaded. I think the dangers and the things like bias and those kinds of things, nuance, are very much out there in the conversations. But I think it's recognition that it's not just being able to interrogate the technology, it's also about being able to interrogate your own procedures, your own ways of working in your firms, in your work environment. Responsible AI use and adoption comes with procedures, it comes with expectations, it comes with literacy. Digital and AI literacy are critical skills. And I think adoption rates are directly affected by the level of skill a person has. Sometimes we are finding, and I've worked recently with the Pretoria Bar on working out a code of conduct. And part of, number one, at top of the code of conduct is the fact that advocates of the Pretoria Bar are required to undergo skills training, digital and AI skills training, before they make use of those tools. So it would be a general purpose or a legal tool. So those are things that I think you need to take into account. You also need to be able to have someone with enough technology background to be able to evaluate the tool, its use, its boundaries, its limits, and where it would be best suited in your firm. So responsible adoption is a very wide and loaded word. It's not just about governance and rules and bias and making those things. It's a much wider responsibility.
And thanks for that, Sylvia, and we'll come to that throughout the second segment on risks. Fola, let me turn to you for this last part, and I think zooming out a little bit from the conversation, the rules are being written about AI in arbitration. The question is who is writing those rules and for whom, and so really, how is the international arbitration community kind of shaping its own AI future, and also what's the impact here in Africa really about those developments?
Thank you, Alex. But just to quickly pick up on what Sylvia said and what Sarah said, I think the point you made about AI literacy is quite key, because Sarah, you spoke about this idea of delaying introduction to AI use in a law firm, and I do wonder whether, given the reality of graduates today and their inevitable use of AI to fast track, their work, is delay the answer, or really just focus on AI literacy and kind of just immerse them into this idea of responsible AI use?
Sorry, it's not to say that you shouldn't also be training them in AI use. It's a question of how much you allow them to rely on AI in the production of their work at first. So at the same, it's a kind of a parallel training. It's training in the original kind of way we would have trained juniors, but also training them in AI, but not allowing them to rely on AI entirely right away.
Fair point, because as a professor, I'm now faced with this situation where I get answers which are all virtually entirely AI generated, and how do you deal with that? To your question though, Alex, in terms of what's happening in arbitration, so we have seen some positive development that's been happening. The Silicon Valley Arbitration and Mediation Center, which is a non-profit, in 2024 released a set of guidelines in relation to AI use. The Chartered Institute of Arbitrators also in 2025 released their own guidelines on the use of AI. And I'm just using those two frameworks as an example, the Stockholm Chamber of Commerce, as well as the Vienna International Arbitration Center, have also released their guidelines. But if you use the Silicon Valley Arbitration guidelines, as well as the Chartered Institute's one, there are areas of convergence that we're seeing in terms of guidelines being issued for AI use in arbitration. They have principles around human responsibility, the use of AI to ensuring that it doesn't diminish responsibility and accountability, either by arbitrators or by the people who are appearing before arbitration. There's a rule around non-delegation. Do not relinquish decision-making powers to AI. They all acknowledge what is called the black box problem, which I think is what your own tool is trying to solve for, which recognizes the necessity of human oversight and trying to make sure that you have human oversight over the accuracy of decisions, and it's recognized that it can encumber the obligations to furnish transparent and truthful justifications. There are rules around confidentiality. Don't upload confidential data in the AI tools, and there's an acknowledgement around hallucinations as well. And it's quite clear that as you've all rightly pointed out, that AI is increasingly being used in arbitration. There's a case last year, Orano Mining versus Niger Republic, where the government of Niger was trying to challenge the appointment of an arbitrator, and it was quite clear that the lawyer for government of Niger had used AI in drafting their arguments. There are 5 cases that did not exist. A quote from a case that did exist, but the quote was not actually present in the judgment. But also within the guidelines, there are areas of divergence as well. So, for example, the Chartered Institute of Arbitrators is quite clear about the necessity of being transparent when AI is being used, right? Whereas, in the Silicon Valley one, transparency is not a mandatory requirement. That is left to the discretion of the users on a case-by-case basis. And then you have some important template agreements that have been developed for parties to agree on when AI is going to be used, for them to also have a right to veto whether AI is going to be used in arbitration proceedings or not. But all these frameworks are obviously non-binding. But I think what is potentially missing and what hasn't been replicated within the arbitration ecosystem is having a principles-based approach towards governance. Because if you look at some developments that's been happening within the judiciary, especially in the Canadian context where I work, you have a principles-based approach to governance. And the reason why a principles-based approach to governance works is because, the development of technology is so rapid that, the law typically has a pacing problem. It doesn't, the law you pass today potentially becomes outdated in a couple of years, depending on, how technology has evolved. But when you have a principles-based approach to governance, that's more or less potentially timeless, because those principles more or less will stay the same depending on, the technology adoption. And a lot of these guidelines that I've seen within the arbitration context are not really adopting a principles-based approach to governance, which is where I think the potential shift to potential shift should be headed towards?
Thank you, Fola, and for summarizing what we're seeing, at least in the governance in the arbitration world. Last point, maybe I think which is something that people are worried about, which is the uneven adoption and the privilege that some firms with bigger revenues may have over less, and creating this two-tier system where those who can have sophisticated tools will have, I mean, this is not a new problem, to be honest. We've seen those in arbitration for other issue, but is this compounded by the arrival of AI, and is African arbitration at risk with this two-tier system? What's your views?
I don't necessarily think that it's at risk. I think that the arbitration ecosystem on the continent is actually fairly well developed. So I don't necessarily see it as a risk. I do think that if you take it beyond arbitration and you look more broadly at what's happening in terms of AI on the continent, then yes, you've got this diffusion taking place. South Africa was engulfed in a scandal just a couple of weeks back when the national air policy had to be withdrawn because aspects of it had been developed with generative AI. But you are seeing pockets of bright spots across the continent where they're taking a number of innovative approaches towards AI governance. And I know you've spoken about how at the Pretoria Bar they're now introducing codes of conduct, which is kind of more consistent. What's happening elsewhere in terms of legal practice. So I don't necessarily see the African continent lagging behind in terms of adoption and guardrails for its use.
And I will add to that there is such a fierce competition around AI tools. Prices are going down. You have even freely accessible AI tools. I mean, and legal AI tools. And if you're seeing even yesterday, they've been few announcements about, and so the competition is really going down. And I think there is a sort of a leveling playing field, also arguments in terms of adoption. That moves us a little bit to the second segment, more about risk, and you've already touched upon governance. We've heard about black box, we've heard about bias, hallucination, and every issue at risk and limitation of AI tools that we know of, that we've come to understand throughout the years of conversation and conferences that we have. Sarah, let me turn to you as our practitioner on the panel, and really with a sort of grounded version of the question. Have you encountered? You've already touched upon what you've seen, like from opposing counsel using AI, that you are actually able to spot that there has been some use. Have you seen AI creating concrete due process problem in case? Is this still theoretical? Are you able to spot them as you've already touched upon?
Yeah. So I haven't personally had a case where AI has directly caused a due process challenge, but we certainly need to be careful not to draw too much comfort from that. I think, as I said, there's patchy adoption, and the greater the adoption, I think the greater the risk of this becomes. There have, however, been situations that we've seen where certainly a risk could have arisen if things hadn't been caught as early as they were. And I think the industry has to be very, very careful to watch out for the types of risks that can arise that would create due process risks, including things like you've mentioned, an asymmetry in the tools that different parties might have. We've seen and pressure from firms who do have capabilities for timelines to reduce, that can potentially create issues relative to a firm that doesn't have the right sort of tools, trying to produce outputs at the same sort of speed, can create a lot of pressure, which could create risks for process. There's, of course, the disclosure question that you've raised as well, which I think is quite critical in relation to what to the outcome of the arbitration, but also risks in relation to kind of the very nature of its confidentiality. And then, of course, the question of how arbitrators might be using AI in formulating their awards. And I know there's an enormous philosophical debate around what extent they can and should be using AI, and whether this impacts the actual integrity of the deliberative process. These aren't theoretical concerns. They're live questions that the industry is working hard to try and draft a proper framework for. And I think our friends who are doing so really have to think quite hard.
Thank you, Sarah. And I mean, those are in fact real issue, real question. You've probably have seen that recently an award has been annulled. I think it was in Canada, because the arbitrator used AI, fake citations. So we've seen that from the side of counsel, but we're now seeing that also from the side of arbitrator. The award has been annulled on that ground. And so these are indeed a very serious and practical question. We'll come to the disclosure part in a second, but Sylvia, let me turn to you again, try to zoom out here on more on the accountability part. When things goes wrong, who is accountable for AI-assisted legal work, counsel, institution, us, tool providers, but mostly are the existing law and the existing framework really capable of protecting and give us like a workable answer to those questions?
I think, yeah, the short answer for now, who is accountable is obviously the professional who is responsible, and that is the human practitioner. You are the face of it, and as a number of cases across the world, you cannot file a fabricated citation and tell the tribunal, I did it. It's not working. It's just not flying at the moment. So those have been rejected with costs, with a lot of other consequences on both ends of the panel. But I think we're also, again, focusing on some of the wrong aspects. We're focusing on accountability when things go wrong. The harder question is foreseeability. So traditional liability asks, what would a reasonable professional have done in that circumstance? And generative AI is probabilistic and non-deterministic. So it's the same input can produce different results, different tools, different results, and that's how we traditionally think about professional tools. So existing frameworks are workable, only because AI hasn't yet been truly embedded in decision making. So we found ways around it. The professional is held liable and accountable. Soon service providers will also, as the lawyers get smarter in their service level agreements. So I think when you see it being embedded in your decision-making levels, and you have enough disputes to force the issue, then we will see a little bit of a shift in governance frameworks and how that is worked out.
That brings me to the question that I think everybody's still grasping a little bit, which is of course about disclosure. Fola, you already mentioned the Silicon Valley Arbitration Mediation Center guidelines. You mentioned the Chartered Institute of Arbitration guidelines. There are many underway. I mean, the IBA AI Guidelines Drafting Committee, they're coming up this year. There is the ICC Task Force on AI also reflecting on that. So we're seeing a myriad of really soft law thinking around those issues, all coming down to this very one issue about disclosures. And fireside question to each and every one of you: should disclosure of AI be mandatory in arbitration? For whom? Counsel, arbitrator, for equally for both of them, and who should enforce it? $3 million question. Go ahead, Sarah.
All right. So, of course, there are varying kind of views on this. My personal view is that I think there should be a level of disclosure from both arbitrators and counsel, but that I think the answer is different, what that level should be. For counsel, I think it's probably important for the tool used to be disclosed. I think parties have an inherent interest in the confidentiality of the proceedings, and we know some tools simply aren't geared to protect that sufficiently. So I think the precise tool that is being used should be disclosed. I also think that it might be appropriate to disclose the types of tasks that you'll be using the AI tool for. And the reason I think that is because of the tribunal needing an ability to assess the equality of arms concerns that we've already discussed. If the tribunal doesn't know what tasks might be performed by AI and therefore inherently more quickly and more efficiently, I don't think the tribunal can accurately assess the appropriateness of timelines and the fairness in them. For tribunals, I think more detailed disclosure is important, and that's because I think ethically and I think from an enforcement perspective as well, arbitrators simply can't delegate the exercise of their judgment. And I think it's important on the face of the award and from the record of proceedings to be able to assess precisely what the arbitrator has done and used AI for. And of course, there should be very clear lines and limits around what the arbitrator, the tribunal is using AI for. And it's, I think, important for the integrity of the process and trust in it for parties to be able to assess whether those lines were crossed.
Interesting. I would take some issue about maybe being too restrictive about the disclosure of AI, especially from the side of counsel. And I'll give you the example of Jusmundi. I mean, we've been using AI forever, and now, okay, it's generative AI, but before that it was extractive AI, and nobody would have ever thought about, okay, I'm disclosing the use of Jusmundi. Okay, now it's use AI. But you're right in the sense that some might incur into concern because if you're using it for, I don't know, witness preparation, et cetera, but these are interesting thoughts. I'll give the floor to Fola on that same question.
I fully agree with what Sarah said. I think that, there should be a level of mandatory disclosure, especially when it can affect proceedings. I think that's when you're using generative AI for, other simpler tasks like improving, your, drafting and language, that kind of disclosure might not be necessary, right? But I think what underlies the question you're asking, I assume is a question of responsibility and accountability, right? And a question I'll put back to you is, well, how do you determine responsibility if the potential error is invisible? So for you to surface, responsibility and accountability, there needs to be a level of visibility. And that's where transparency comes into play. And, Sarah, I think, has helpfully highlighted how, the threshold for transparency and how it should apply to the different parties.
Interesting. So accountability comes from transparency, and so hence disclosure. Sylvia?
Yeah, I think it's more of a targeted disclosure for me. Why are you disclosing? I mean, we don't sit there and say, Alexander, you are using a Lenovo laptop and you are using an Apple and you are using a Dell. We don't sit there and discriminate tools. We don't use, you are using Google Docs, I'm using Microsoft Word, whatever the case may be. Those are things that are irrelevant to your outcomes. So I think you need to be very careful where you target that disclosure. Not every single little aspect needs to be disclosed. And you've got to think about the reason for disclosure. From a client perspective, it's going to be if the arbitration goes my way, I have gained a lot out of it. I'm not going to be too worried about what you did to get there. But if I'm on the losing side, I'm going to be a little bit more particular. And I'm going to want to be able to challenge that decision and hold someone accountable for their actions or inaction, as the case may be. I think you also need to factor in costs where it affects costs. There, I think disclosure is quite important. But mostly it's about being able to challenge and understand what the AI did, where it affected the case, and whether you as a layperson are able to challenge it effectively and hold the right parties accountable for their actions.
I think we arrive a bit at a consensus in terms of, but it is part of common sense, part of current regulation, and I think where we see the most sort of crux of the issue is really on decision making, which brings us to the last part of our discussion today, which are really the red lines. And so one of the big headlines was, of course, the AI arbitrator that the American Arbitration Association came up with about last year. So it's a very nice marketing name, but it's not an entirely AI arbitrator, and it's for now has a very limited scope, which is construction case under a certain limited value, documents only arbitration, but it still signals a very important shift. We are also working with arbitral institution to automatize some part of the decision making. We know and we sell UCI to arbitrators. We know that they're using it for awards drafting. And so AI come into decision making in a way or in another. And that brings us to also the disclosure part, which we just address. Maybe I'll just take a step back and I'll come back to you, Sylvia. You did that little experiment 2 years ago with precisely here at JOY in 2024 about trying to draft an award with ChatGPT. Would love to do that again with UCI next year, maybe. But what was your takeaways from that experiment? What really came out of that? And yeah.
I think it was a very interesting experiment, although not very scientifically sound. Just to put it in context, remember in 2024, we were in the very early iterations of ChatGPT. It was before we had any reasonable legal specific AI tools available. And at that stage, I've got to say the award that it generated, ChatGPT, the general free
version
model, was pretty competent. It didn't manufacture citations. It actually used general knowledge cases. What I think was very interesting was that it came to a different conclusion to the human panel, because it was compared with a human panel who listened to the same arguments on the same papers. And I think what was also interesting was the fact that, I forget the exact percentages now, but quite a large percentage of the audience, practicing legal practitioners, actually found it to be a pretty competent award. And that was general AI, not trained on legal material, legal doctrine, legal reasoning, or anything like that. It was a practical, open-ended. I thought that was it was very interesting, and it was definitely eye-opening, and I accompanied that experiment with a speech on, that was great and very impressive, but wait until the legal tools come out. And it took about a year and a half after that, and we have very, very competent legal tools. So I think what struck me was it was competent, a little bit vague, a little bit shallow, but I think a lot of the legal tech tools out there have compensated for that problem. Also, with your closed system legal tools, you don't have the problems of hallucinations as much. You have more ethics being built into those systems, so your bias and that kind of thing is phasing out. I don't think it's been completely addressed, but it is less than what your general purpose AI is.
Yeah, no, and I can definitely tell you that the technology over the last 2 years has evolved. We've done some similar tests during the Vismut and also with SciArb, where we actually had like human teams versus UCI, and the results were pretty impressive. And you know, we had blind judges saying, okay, which award is from where. We did that here also. So there is the possibility that can happen. Sarah, from a practitioner perspective, could you advise a client to consent to maybe the AAA AI arbitrator scenario?
Yeah, look, it's very interesting, of course, and you can see the attraction for clients: speed, cost, consistency, efficiency, and why it might be attractive, particularly in high volume, low value disputes. We see clients in other kind of manners making a decision for a less robust process and less robust decision in adjudication, for instance, where timelines can be incredibly reduced, and actually they just want kind of a quick outcome regardless of what it is, to move on. So I can see a push for it in the future, but in my view, I don't think we can responsibly yet advise clients to take this option. I don't think we have the right kind of frameworks in place for it. We need to think carefully about whether such a thing would be enforceable under kind of the right legislation in any enforcement jurisdiction. It's a complex question about whether it would have the effect they expect it to. But I don't think probably ever in cases of real complexity or consequence. And that's because of the human judgment element that I think we will always expect, and clients will always expect. I think they do want a nuanced assessment, particularly in cases where factual evidence is being weighed and you're assessing the credibility of witnesses. I don't think that clients and parties will ultimately find a system where that's being done by a machine to be one of integrity. And I think if we moved to a point where we were outsourcing all of the decision making in these processes, we might have a trust deficit, and really we'd be left with a situation where what we've got is output rather than judgment, and I don't think that's what most clients want.
And I think the critical questions and the most difficult, especially if you look at those guidelines, is what is decision making? Where is decision making? I mean, we talked with arbitrators on a daily basis, and each and every one of them has a very different approach into where they might be comfortable using AI in drafting an award and where they might not be. Some tells us procedural part of the award, totally fine. Summary of parties position. Here we have mixed answers. Some of them say no. Well, I'm actually summarizing the parties' position. I'm already in the process of decision making, and so here using AI is already using it for the purpose of decision making. And you see here the thresholds are very, when is it that you're using it for improvement purposes? When is it that you're using it for assistance, as opposed to when you're using it for decision making? And maybe last question for you, Fola, before we wrap up and we open the floor, because I'm sure we'll have a few questions really about that, and more on the African governance perspective. By the way, I think was it you who told me that the AI national policy of South Africa that was being drafted has been put on hold because precisely it was drafted with AI and was wrong?
Well, to clarify, just aspects of it was generated, and it's quite unfortunate, really, because I was part of the 40-person committee that was drafting the national AI strategy. It was a very robust process, and then the government decided to fold up the national AI strategy into the national AI policy, and then it went into a black box in government for about a year, and then it came out, and then you had this policy which they used AI to generate aspects of it, and you know, that speaks to a lot of things, because when you already had this robust process with experts in the room helping you to work on a national AI strategy, and then you take it back, and then you pretty much then just abandon all that human interventions.
And it came back with AI hallucination. Yeah. Interesting. No, but back to our more serious question, really on what do you see in terms of African governance? And again, on this question of decision making, and you mentioned the guidelines. Do you think we are sufficiently equipped? Do you think standards are emerging, especially here in Africa? I mean, you've been involved in various national AI strategies. What is your final take on that point?
Well, I mean, I think so. We haven't seen any hard law come up yet, right? You know, in Kenya and Nigeria, they currently have proposed legislation on AI. You know, what we are currently seeing on the continent are strategies and policies which are not really enforceable, and they are more or less statements of commitments by states around, you know, how they want to position themselves in the AI economy. And a lot of these emerging frameworks also frame, you know, AI adoption from an economic perspective, less about, you know, ethical and responsible governance, right? So, you know, the National AI Policy of South Africa, before it was withdrawn, did have some very interesting things about ethical use. And also the Chartered Institutes of Arbitrators, which I found quite interesting, you know, spoke about arbitrators considering the environmental impact of AI, right? Which I found very progressive, that, you know, think about your own agency when you're using AI, and think about the impact that your use of AI is also having on the environment, right? I wouldn't expect to see something like that within the guidelines issued by the Chartered Institute. So, you know, I think that, you know, when, from a South African perspective in particular, when the national AI policy is eventually released, I don't expect it to change. I think they're just going to address the parts that had hallucination within it. It has some very, very progressive aspects around, you know, responsible AI use. Of course, the fact that it's recommending 7 different types of institutions to govern AI is potentially batshit crazy. They potentially are going to revise all of that, but, you know, bright spots exist within it.
All right, so our time is up, but we will give you a couple of questions if you want to. But before doing so, and I've seen the gentleman, I will ask one final word to each and every one of you. So for AI to strengthen, sorry, difficult word in English, rather than erode trust in arbitration, what is the one thing that cannot be compromised? Sarah.
Sorry, Fola was trying to drop the mic a little bit too early, but
Boom.
For me, it's we have to retain human accountability.
Human accountability. Fola, same question.
I agree that human oversight is needed. Yeah.
Sylvia, last word.
I'll be in agreement. The only thing would always be retain the humanness. And yeah, I think I'm most excited about access to justice that AI offers. I think it's incredible, especially for Africa. Access to justice is a huge issue, and I think that is one of the standout features of the American Arbitration Association's use of AI. If it works, it's great.
And we couldn't agree more, and we finish where we started. Again, our mission at Jusmundi is precisely to help and to foster that access to justice, to resources, and we believe that AI is really going to be game changer into that. But we had, of course, a very nuanced conversation here today. So I see that there are 2 questions, 1, 2, 3. You had your raised hand, so, or if you want, there is this mic if you want. Perfect.
Thank you. I'm an engineer, so let's start off there. So I'd like to draw a parallel to engineering. What you are facing now as engineers, we're embracing technology. And one of the big challenges we have is with technology, especially with young engineers, they can do the sums and they can run the programs and they come up with answers. But do they have the knowledge and the experience to evaluate that answers. The computer says it's there, it must be right. And I think that is one of the big challenges we have now, is you say you can lose the younger people learning, but eventually, where are they going to learn to be able to evaluate something later? And I think that is one of the big challenges you have.
Thank you.
I love AI. I use it wherever I can, but
Okay.
I think that could be a challenge.
Thank you for your comment, sir. We're going to take just two quick questions. The lady here and then the sir there.
Thank you very much. My question is from a university perspective, how far are you as law schools or law faculties in, there's legal research or legal skills. I'm wondering, with AI now, have you guys agreed on a core course or a structure how you can teach it to the LLB students? Because we know that they're already using it. We might as well make it a core course to teach them how to use it correctly.
Very good question. We have two professors here. So,
okay, thank you. I'd like to start by congratulating the panel.
Thank you.
My question is as follows. Considering that AI is evolving day after day, do you think that the use of it in international arbitration or in arbitration, including domestic, should be regulated by the national legislation, or it is an issue that should be left to soft law? Thank you.
Two very big questions. So let's start with the education question first.
Well,
Voilà.
very quickly on the last question, I'm a big advocate of sectoral-based regulation. So when it comes to AI and arbitration in the judiciary, I think you need a sector-specific, regulation, either enforceable or soft law, but certainly not a national framework, right? And then in relation to education, I think so. I wear a couple of hats. I offer 3 different courses on AI. One is on economics of AI at Wits University, and one is on AI ethics and policy at UCT. Granted, these courses target, professionals and graduate researchers, but it's also something that undergraduate students potentially will benefit from. But specifically to your question about AI in research, I know that at my home university, St. Mary's University in Canada, that is something that has become quite mandatory now, and offering students, specific Gen AI accounts and teaching them the responsible use of AI. I don't believe that we have that in South African universities just yet. So it has been left to the discretion of majority of my colleagues within the South African context to talk about how AI is adopted in their own teaching and learning. I certainly know that, for some specific classes that I teach, where core legal reasoning is important, I've now resorted to actually offering exams with pen and paper, primarily because of the problem of generative AI. But I don't know if it is different at University of Pretoria.
Yeah, I've got to say, we've done a few things on the education side of things. One of them is going, at least one assessment has to be a pen and paper. So it's back to the red pen and marking hours. More problematic is the legal research essays component. That we have at the University of Pretoria introduced an oral exam afterwards. In other words, to number one, upskill your oral skills, and number two, to make sure that it isn't an entirely AI-generated essay that is submitted, that you have the legal reasoning, you've done the research, and you understand the topic that you're talking about. So those are two immediate things that we have implemented at Tucky's, at least. And then in 2027, next year, we will have law and technology as a core module. So unfortunately, intellectual property law has had to take a back seat. And it has been replaced with law and technology, which has both a theoretical side to it, as well as a practical use of AI. So prompt engineering is part of that. The ethics behind using AI, those kinds of things have all been built into a course. So that is from next year. So those students will benefit from that. It'll be introduced at a third-year level. And then we're also looking at implementing a legal skills lab with legal tech that students will be able to use and will be required to use in producing certain of their assessments.
Happy to help on those when they come up. I have a little announcement to make before we close this session. So for those of you who are attending the gala dinner, it will commence at 6:30. So you have an hour to go back, get changed, put your best outfit for this amazing gala dinner. And you can only attend if you are registered, I'm afraid. So help me in thanking those amazing panelists for their remarks today. Thank you very much. And again, thank you to AFSA for this very great Johannesburg Arbitration Week. See you later.